I know this is important to you.
All right, good afternoon, everyone. Are you able to hear me?
Good afternoon, Judge.
Yes, Your Honor.
Thank you. Good afternoon. Good to see everyone. This is the State Expedited Accusations calendar in the State Court of Fulton County. I am Judge Melanie Williams. Today is February the 23rd of 2022. This calendar is for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants on the screen, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. I want to advise all particular participants that this is actually being recorded and live streamed over the internet, which means that any member of the public can log on and watch this particular proceedings. Before we begin, is there any outstanding matters from the state or defense? Does anyone still need to speak with their client and has not had an opportunity to do so? All right, hearing none, we can start with the first position.
Your Honor, I also see the interpreter is here. If I can inquire for which case so I can put it in my notes.
Madam
Yes, Your
Interpreter.
Honor. Yes, ma'am. Good afternoon. I was called for Mr. Andres Mojica Paz.
Okay, is it possible to take that position first by any chance at the jail?
We're actually gonna have him be done in courtroom 3 while we still continue on with the other cases.
Okay, I tried. All right. Who do we have first?
We have position number 17, Ms. Purple, and we are, actually another officer is gonna go to another courtroom, courtroom 3. And if we can be sent the Zoom number or, let him in.
Yes. All right, if we can, Miss Middlebrooks, if you could send the Zoom information to the jail somehow so that they can assist with getting courtroom 3 online. And we need to be put in a breakout for position 17 before we begin.
We have the Zoom number. It's just that if you can just let us in.
Okay, that should be fine. If we could be put in a breakout, please, I believe it will be me, Miss Guidry. And who represents Miss Purple?
I do, Your Honor. Good afternoon.
Good afternoon. And Ms. McLeod, Ms. Guidry, who else are you requesting that join you in the breakout? Are you requesting that your supervisor join as well?
Yes, and Your Honor, this is a co-defendant case with position number 7, Toreen Du Bois.
Okay.
Okay, Your Honor. So we have you, Ms. Guidry, Ms. McLeod.
And Your Honor, if I may, Bruce Dale from the Public Defender Office, I represent.
I'm sorry, Mr. Vale, you faded out at the end.
I represent Mr. Du Bois, Toreen Du Bois, the co-defendant.
Okay. I'm not sure that we need Mr. Vale. Are you requesting to join in to hear this breakout, or were you just making me aware?
I just wanted to make the court aware, Your Honor.
Okay, I don't have any objection to you joining the breakout. There might be some relevant facts we could discuss all at once. So can we add Mr. Vale as well? And Ms. Guidry, who is it Ms. Falk you need to
Yes,
join?
Your Honor.
And Ms. Falk, please add Ms. Falk as well to the breakout.
That's
And
going to the
Your Honor, if
breakfast
we
as well.
can address Mario Bibbs in the breakout as well, that's position 2.
Well, let's stick with co-defendant and defendant. I'd like to not, let's not do it all at once. I'm not sure that I would remember by the time we got back to position 2 and we were back in there again anyway. Ms. Kim has also requested to be added to that breakout as well. There's going to be a very large breakout, Ms. Middlebrooks. I'm going to try to recite it again. Please add Ms. Falk, Ms. Guidry, Ms. Kim, Ms. McLeod, and Mr. Vale. Is that correct? Did I leave anyone off?
Yes, Your Honor, I would ask that attorney Jose Segura come in as well. He is a new attorney with our office and I would like him to see the procedure.
All right, that's no objections to that. Ms. Middlebrooks, do you have everyone that needs to be added?
Yes, one moment. You said for me to send a link to the jail as well?
No, they have the link. They just need you to be able to let them into the Zoom conference. That was their
Oh,
only
okay, so-
request at the jail.
Okay, so there's Miss Guidry, Jose Segura, Bruce Bell, the judge, Miss Bridgewater, McLeod, Kim, and Falk.
Yes.
All right.
We got the Spanish interpreter available?
Yes, sir, I'm available.
I'm gonna need the Spanish interpreter and Miss Kim in the breakout.
All
Okay,
right,
Miss
let
Kim
me
is in the breakout room right now. When she returns, we'll put you guys in the breakout room.
Thank you.
You're welcome.
I'm hearing some background noise from someone. We are still on position. We're on position 17, Ms. Purple. Your case is 22 CR 0000989A. I went into the breakout and I spoke with your attorney regarding this case. Did you have any objection to us conducting this video by conducting this hearing by video today, or to your attorney assisting you by video, Ms. Purple?
No, ma'am.
Okay, I've heard information from both the state and the defense, and I am going to set bond as follows. All right, on count one, Ms. Purple is going to receive, I'm torn about this a little bit. Can we go back into the breakout for one? I apologize. I have one additional question. Miss,
The breakout room is still open, Judge. You could just go back into it.
I don't know that that's accurate. Let's try. I believe you, but I don't see where it's giving me that option. I did have one other question for the prosecution.
So do you want the same people in the breakout room? Or?
Yes, I apologize. I do have one other question.
Okay, hold on.
I return. Can I be placed back into the breakout room?
I think Ms. Middlebrooks is doing her absolute best to get us all back in there. And this is, I should have asked this question earlier. All right, I have, because of the unique facts of the case, I have really struggled with this. But at this time, Ms. Purple is going to receive $500, $2,500 signature bond through the jail for count one, and a $2,500 signature bond for count two through the jail. And she must stay away from 241 Peachtree Street. She is to have no weapons, drugs, or alcohol as a condition of this bond. Are there any further questions from either the state or defense regarding Ms. Purple's bond?
Yes,
Nothing
Judge.
further.
I was
All right.
So will you repeat it? Was it?
I'm sorry, Ms.
25?
Bridgewater. It's 2,500 signature on each charge, Ms. Bridgewater.
Okay, is that through the jail or?
Through the jail, yes, ma'am. Are you able to hear me now?
I can. I was one of the last ones to get back inside the.
Oh, I started speaking without you. I apologize, Ms. Bridgewater. For a total sign-on bond of $5,000, all right? Best of luck to you, Ms. Purple, and please stay away from that location and don't engage in that ever again, all right? Take care. Who do we have next?
Your Honor, I apologize. For some reason, I was delayed getting out of the breakout room and I didn't hear what you said.
I probably should have taken a beat to make sure you all arrived. It's a $5,000 signature bond through the jail. She is to stay away from that incident location on Peachtree Street, Ms. McLeod. All right?
Thank you, Your Honor.
All right.
Your Honor.
Yes.
Courtroom 3 is ready for the interpreter and Ms. Kim to go in the breakout room.
Okay.
I need someone to send me like an invitation to the breakout room so it can pop up on my screen.
Who represents position 3?
Okay, I was just letting you know, Your Honor, so whichever next case you got ready to take, if it was with Miss Kim.
Okay. Ms. Kim, you had an opportunity to speak with your client. Have you already spoken to your client? Ms. Kim, you're muted. I can't hear you.
Not yet, Your Honor. I was waiting for Miss Interpreter.
Okay, so you need to be put in a breakout so you have an opportunity to speak with your client.
Yes.
Is that correct? Can
Yes.
we do that? And if possible, at the jail, can I go to the co-defendant case while they're in the breakout? I'd like to go to position 7 if possible.
That's fine. Yes, good job.
Thank you.
Okay.
All right. And Ms. Kim, if she could be put in the breakout with the interpreter. All right, Mr. DeBose, your case is 22 CR 0000988C, in which you're charged with 1 count that I will not sound, and the 2nd count of possession and use of drug-related objects with an offense date of February the 22nd. I've advised you of your constitutional rights. Do you have any objection to a video hearing today?
No, ma'am.
All right, thank you. Mr. Vale, you represent him, and I believe I have all the facts before me as we discussed in the breakout. Is there anything further from either party at this time?
Nothing
Nothing
further.
All right, for count 1, I'm gonna do a split bond here. All right, count 1, Mr. DeBose is gonna receive a $1,500 signature bond through the jail. Count 2, he's gonna receive a $1,000 surety bond. And he must stay away from the incident location as well,
And Your Honor, no alcohol, drugs, or weapons?
as a condition of this bond, no alcohol, drugs, or weapons.
Okay.
All right, is there anything further from either party as it pertains to his case?
Nothing further from the state.
Nothing from the defense. Thank you, Your Honor.
All
Your
right,
Honor, just to get clarification, the surety bonds on the possession of drug-related objects, not
Yes.
the public indecency? Okay.
yes. I was trying not to sound that, Ms. Falk. All right. I believe that concludes his case. We can move to the next position.
Next will be position 2, Mr. Bibbs.
Your Honor, that's a breakout as well.
We're doing a lot of breaking today. This is a good thing. All right, Ms. Middlebrooks, let's see if we can figure out who needs to go into this breakout. It will be me, Ms. Guidry, Ms. Falk, Mr. Vale, I'm assuming, and Ms.
Right.
Kim is preoccupied, so I don't believe she'll be joining us. And it was another member of the solicitor's office. I forget who that was.
Jose?
Mr. Segura, yes.
Mr. If you could put those people in the breakout, Ms. Middlebrooks, I would appreciate it. And I promise, and Ms. Bridgewater, please.
If his caseworker is on, may we put her as well? Her name is Shanika Hatcher. I don't know.
Yeah, I don't, do we see if Miss Hatcher is on, please add her to the breakout.
Okay,
as well.
sister.
I'm sorry,
I'm his sister. Should I be in the breakout room?
not at this time.
I said I'm his.
I understand,
Okay.
thank you, but not at this time. All right, if you could
Which
put us on,
defense attorney?
Mr. Vale.
Okay. Sorry, hold on.
Okay, we need to be placed in a separate breakout.
Yeah, hold on 1 minute. Give me 1 second.
What happened?
I was mistakenly removed from the breakout room with Ms. Kim and her client, Mr. Mojica.
1 minute. Assigned to 6 is interpreter. Shake him. Courtroom 3 and hold on. Interpreter courtroom 3 and shake him. Okay. Assign these people to 7. To 7. Assign to 7. Judge assign to 7. Assign to 7. Assign to 7. Beautiful. Miss Bibbs?
She was the
Oh, it's under Melissa.
Okay.
I'm gonna
Yes.
add you to the breakout room,
Hello?
okay?
Okay.
All right, have all parties returned from the breakout room?
Yes, Your Honor.
Ms. Bridgewater, are you with me?
I am with you. However, Ms. Bibb said that she can't get out of the breakout room. Can someone assist her on how to get out of that breakout room? Ms. Middlebrooks, can you help her get out of that breakout room?
Your Honor, I'll go back in and assist her. So you guys can,
We'll wait for you, Ms. Falk, because I think that, let's see. We're doing a lot of breaking out today. In the meantime, Mr. Bibbs, your case is 22 CR 0000974J, in which you're charged with 1 count of disorderly conduct and 1 count of obstruction with an offense date of February 2022. I've already advised you of this. I believe all the attorneys are current and present on the screen. In the breakout, I had an opportunity to hear from the attorneys as well as some statements from your sister. At this time, you are gonna, I'm sorry, I apologize. Ms. Guidry, what is the bond currently set?
He has no bond currently set.
He currently has no bond set. All right, I wanted to make sure I understood. And the state's recommendation was 1,500 surety on count 1 and 1,000 surety on count 2?
Correct.
All right. Is pretrial on the line yet? Was Mr. Howard able to get in? Okay, Mr. Howard, remind me, was position 2 recommended? I wrote it down, but I can't remember.
No.
Not recommended. Okay, thank you. All right, at this time, Mr. Bibbs is going to receive a $1,500 surety bond for count 1 and a $500 surety bond for count 2 for a $2,000 surety bond. He is to stay away from the incident location and have no further contact with the victim, last name Colbert. I've made some recommendations to all parties in the breakout. I hope that those will be pursued to get Mr. Bibbs in a great position. If there's nothing further from either party, we can move to the next position, and best of luck to you, Mr. Bibbs.
Next, position number 1, Ms. Takesha Anderson.
Okay.
Hi, Your Honor. I'm here for Miss Anderson.
All right, thank you. And your name for the record?
Jamie Steinhaus.
Okay, good afternoon, Ms. Steinhaus. And good afternoon, Ms. Anderson. Ms. Anderson, your case is 22 CR 000980G, in which you're charged with 1 count of battery family violence with an offense date of February the 22nd of 2022. You heard me advise you of your rights to remain silent and your right to an attorney at this proceeding. Do you object to a video hearing or to Ms. Steinhaus assisting you via Zoom today?
No.
Thank you. Mr. Howard, she's recommended first arrest?
Correct.
Thank you. Whose case is this for the state?
It's mine, Your Honor.
Okay, good afternoon, Mr. Segura. What is the state's recommendation?
The state's recommendation is a $3,000 surety bond, no alcohol, drugs, and weapons, a stay away from the property, 200 Pinnacle Point, Johns Creek, no further contact with Mr. Anderson, a 1-day anger awareness, one-time police escort to retrieve her belongings, and a third-party transfer of children.
Okay. Do you want to give me very briefly the basis of the state's recommendation? Indeed, our recommendation is based that there's a high risk that she'll commit the crime again, mostly because Jamal Anderson, spelled Jamal, Anderson, common spelling, showed a video to the police of the defendant verbally confirming that she bit him and that she'd do so again. And there's also some other facts that Mr. Jamal Anderson is a defendant's husband who lives together in the same house and who shares 2 children with her. It's also worth noting that the defendant was arrested at 1:20 a.m. this morning, which is barely more than 12 hours, and does not have sufficient cooling off period. We also communicated with Mr. Anderson earlier today, and he stated that he does not want further contact with the defendant, that there was violence in the relationship and has escalated, and the police were called out due to the violence, but no one was arrested. And Mr. Anderson also stated that in the previous year,
the defendant has currently trespassed by following and stalking him. And I believe we have Ms. Anderson on Zoom today.
All right, thank you, Mrs. Segura. I'm going to hear from Ms. Steinhaus before I hear from Mr. Anderson. Ms. Steinhaus?
Yes, Your Honor. We would request an OR bond here. Miss Anderson, she lives in Johns Creek, and yes, she has lived with Mr. Anderson. They are in the middle of a divorce right now. It is my understanding that Friday, the arbitration should finish up in their divorce. They do have 2 children together, and she has significant ties to the community as a result of that. She's not a significant risk of fleeing the jurisdiction. She also has plenty of family and friend support right now, in which when she is granted bond and when she is released, she would like to go return her things and then be able to not stay at the house. But I think the biggest thing is that there be not a no contact bond, but a no violent contact bond in this situation. I think both Mr. Anderson and Mrs. Anderson are very aware of the severity of the situation between the 2 of them right now, and there's no objection to any sort of separation at this point. She's got no history of criminal behavior. She poses no threat or danger to anyone in the community or any property. She also poses no significant risk of committing any felonies or intimidating witnesses or obstructing the administration of justice. Like I said, she is in the middle of this divorce right now, or actually nearing the end of it. And because of that separation, I think that no contact, given the fact that they share 2 minor children, is going to be very difficult.
All right, thank you, Ms. Steinhaus. At this time, I'm going to sound for the victim. Is the victim, last name Anderson, present on the screen and would like to be heard at this time?
And I would like to be heard.
All right, Mr. Anderson, what would you like to tell the court today? Oh, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, it will.
All right, Mr. Anderson, what would you like to tell the court today?
First of all, Friday's arbitration, court hearing has been moved to the end of March due to the circumstances. This act of violence by her has only escalated since I filed for divorce in August. I would still like to have some type of contact just in order for us to communicate in regards to the children's well-being and needs. But other than that, there's no other reason for us to communicate.
All right, thank you. Is there anything else you'd like to tell me, Mr. Anderson?
Only, like I said, this is escalated.
All right, I understand.
Since I barricaded myself I barricaded myself in a guest bedroom Monday night when this situation happened, just of concern of her recent behavior since I filed. I had security issued door stoppers under the door, and she pushed her way through the doors in order to get to me. And I think that type of rage should be noted by the courts of I am dealing with somebody that I am deeply concerned about.
Thank you, Mr. Anderson. I think I have a clear picture. All right, since I allow Mr. Anderson to speak, is there anything further from either the state or defense at this time?
None at all.
Ms. Steinhaus, anything further? Very briefly.
Briefly, I would just like to mention that there is a considerable size difference here and that she has not brought any weapons into any of this. So the range of violence, although indicated by the victim as happening, is still, it's just not at a level that would pose a significant danger.
All right, I understand. Thank you. At this time, Ms. Anderson is going to receive a $2,500 signature bond through pretrial services. She is to complete a 1-day anger awareness course. She is to have no further violent contact with the victim, last name Anderson, and she must stay away from that incident location on Pinnacle Point, I believe you said in Johns Creek. She is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party at this time?
Your Honor, it's my understanding that is the shared home at this time. So with the stay away order, would she be able to be escorted to the home, or how would that work?
At this time, I will allow a one-time escort with a member of law enforcement to get any other things. But as a condition of this bond, she must stay away from that shared home.
Okay.
For right now.
Understood.
All right. I believe we've addressed all conditions. Ms. Steinhaus, is that your only case with us today?
That is my only case, Your Honor.
All right, you can be excused. Have a great afternoon.
Thank you.
Take care. All right, who do we have next?
Next, we have position 15, Mr. Melvin.
And after this, we take position 15. Are we able to go to that interpreter case? I can take this one, but I was hoping to allow the interpreter.
Yes, Your Honor, we can go to interpreter case.
Judge, he was not interviewed yet.
I'm sorry, who was not interviewed? Mr. Melvin?
The interpreter case?
I just interviewed.
They
Mr.
were in the breakout. They did it, I believe.
Yes, we were at the breakout room.
By my coworker, they were never in the breakout.
Ms. Kim is informing me that they did complete the breakout session and she interviewed that position.
Okay,
Yes,
great.
ma'am.
Well, you mean position 16, right?
I believe so, yes. That was the interpret.
All
We
right,
can go.
sounds good.
Yes, I spoke with him.
All right, are you Roderick Melvin?
That's correct.
Okay, Mr. Melvin, your case is 22 CR 000-979Y, in which you're charged with 1 count of terroristic threats, misdemeanor, and 1 count of criminal trespass and damage to property. I want to advise you have an absolute right to remain silent. Anything you say with regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. And Ms. Kim, do you represent him?
Yes, Your Honor.
And Ms. Kim is available to represent you. Do you object to a video hearing today, or to Ms. Kim assisting you from a remote location? Do you object to the video? I'm sorry, Mr. Melvin is muted. Can you do you object, Mr. Melvin?
Go ahead.
No, I don't.
Thank you. I appreciate that. Mr. Howard, is he recommended through the jail?
Pre-trial, first arrest.
Okay, recommended pretrial. Thank you. Whose case is Ms. Mitchell?
Yes,
What is
Your
the state's
Honor.
recommendation?
We did request a breakout session for this. I'm not sure if you received that message, but we do have some MH concerns.
Okay. Ms. Middlebrooks. If everyone could indicate who all needs to be in that breakout. We need Ms. Mitchell, Ms. Kim, Ms. Falk. Mr. Vela, presuming might want to be a part of that as well.
Thank you.
All righty, Judge. Do you want Jose Segura back in there too, Ms. Falk?
Yeah, yeah. All right. All right. Is Ms. Bridgewater and everyone back on the record with me? I don't see.
Still waiting on Miss Bridgewater. Okay, there she goes.
All right, making sure everyone is back. Thank you. All right, I believe I have a clear picture of this particular case. At this time, Mr. Melvin is going to receive a $2,000 signature bond through pretrial services. That's $1,000 on each charge. He is to have no further contact with the victim, last name Shakespeare, and he must stay away from that unit. I'm sorry, Ms. Mitchell, will you please put the unit number back on the record?
1418.
1418. He must stay away from unit 1418 at 399 Parkland Drive. He is to have no weapons, drugs, or alcohol unless without a prescription for any of the following. Is there anything further from either party?
No, Your Honor.
No, Your Honor.
All right, best of luck to you, Mr. Melvin. I'd like to go to that interpreter case, please, so that we can release her, if that's possible.
Sure.
Next is position 16.
Okay.
Actually, Your Honor, he currently has $2,000 a bond set up for his 2 charges, and he didn't know about it because nobody translated to him. Since now he knows, he would like to just bond out without going through the trial, if it's okay with the judge, Your Honor.
Let me at least hear the state's, let me at least hear the state's recommendation, all right?
Yes, Your Honor.
Okay, good afternoon. Before I begin, please, Madam Interpreter, please say your name for me. Please state your name.
Good afternoon, Your Honor. Jartu Tolles.
Jartu Tolles. Ms. Jartu Tolles, will you please raise your right hand? Do you swear and affirm that you will make an accurate translation today? I'm sorry, what language are you translating?
Spanish.
From English to Spanish, Spanish to English, to the best of your knowledge, skill, and ability?
I do, Your Honor.
Thank you. Good afternoon, Mr. Andres Mojica Paz.
Buenas tardes, señor Andrés Mojica Paz.
Your case is 22
Good
CR.
afternoon.
Your case is 22 CR 009H78, in which you're charged with failure to yield right of way and driving hit and run, each with offense dates of February the 22nd of 2022.
Señor, el número de su caso es el 22 CR 0000987H, en el cual se le acusa de no ceder el paso al doblar, abandonar el lugar cuando sucedió un accidente, y la fecha de esas infracciones ocurrió en la fecha el 22 de febrero de 2022.
You understand your constitutional rights. You have a right to remain silent. Anything you say can and will be used against you.
¿Entiende usted los derechos constitucionales? Tiene derecho de permanecer callado. Cualquier cosa que diga se puede usar en su contra.
You also have a right to an attorney at this proceeding, and Ms. Kim is available to represent you.
También tiene derecho a una audiencia durante esta diligencia, y la licenciada Kim está presente y disponible para representarlo.
Do you object to a video hearing today, or Ms. Kim assisting you by video?
Señor, ¿usted se opone a que tengamos la audiencia por medio de video hoy, o se opone a que la licenciada Kim lo represente?
No.
No.
Thank you.
Gracias, señor.
All right, Ms. Mitchell, is this your case?
Yes, Your Honor. And
before you give your recommendation, make sure to give enough pauses to let interpretation catch up.
Yes, will do.
Licenciada Mitchell, este es su caso. Sí, su señoría.
Okay.
Go ahead, Ms. Mitchell.
As stated, the current bond is $2,000 good bond.
Como ya se ha dicho, la fianza de caución es $2,000.
And the state requests that the bond remain the same.
El Estado está pidiendo que la fianza siga igual.
Along with conditions of no alcohol, drugs, and weapons.
Y además que se le ponga una condición de nada de consumo de alcohol, ni droga, ni posesión de armas.
In this case, defendant failed to yield while turning left onto
En este caso, el señor acusado no se dio el paso al doblar a la izquierda
the I-285 southbound entry ramp from Donald Lee Howell Parkway.
para entrar a la rampa llegando a la carretera 285 al sur desde Donald Lee Hollowell.
The defendant also failed to immediately stop and remain at the scene.
Tampoco se detuvo de inmediato y tampoco permaneció en el lugar de los hechos.
Of an accident he was involved in,
En el lugar donde tuvo el accidente,
where there was damage to the other vehicle and injury to the driver.
donde el otro vehículo quedó dañado y el otro conductor lastimado.
Although this is defendant's first arrest,
Aunque este es el primer arresto del señor acusado,
his actions did result in a vehicular collision where someone did get hurt.
sus acciones resultaron en un choque automovilístico donde alguien salió lesionado.
Nothing further, Your Honor.
No
All right,
tengo
thank
nada
you.
más que aportar, su señoría. Gracias.
Is it $2,000 total with $1,000 for each charge?
$2,000 en total, entonces $1,000 para cada infracción.
Correct, Your Honor.
Correcto,
Thank
su
you.
señoría. Gracias.
Ms. Kim?
Yes,
Licenciada
Your
Kim.
Honor. Mr. Mosca Paz is 55 years old.
El señor Mojica Paz tiene 55 años de edad.
He came from one of the U.S. territory, Puerto Rico.
Él nos llega de uno de los territorios estadounidenses, Puerto Rico.
On and off, he has lived here in U.S. about 8 to 9 years.
Él ha vivido entre acá y su país natal entre 8 y 9 años.
And he has been a trucker for last 15 years.
Y lleva los últimos 15 años en la profesión de camionero.
And this is his first arrest ever.
Es la primera vez en la vida que lo arrestan.
And he did not actually run away from the scene. He was pulling over to a safer area about 100 meters away from the actual accident scene where the traffic was way too much and it was kind of dangerous to be there exactly. So he just pulled over to be safer and he was there for more than 40 minutes.
De hecho, el señor no se huyó del lugar de accidente, se ahorró para estar en un lugar más seguro, como a 100 metros del sitio del incidente, porque el tránsito estaba muy pesado en el área y para estar seguro decidió ahorrarse. Él se detuvo ahí en el lugar unos 40 minutos.
And he waited, and when the police came, the police arrested without listening to his explanation.
Entonces él esperó ahí y luego cuando llegó la policía lo detuvieron sin escuchar su explicación.
So we would like to request for $2,000 signature bond, Your Honor.
Entonces quisiéramos pedir una fianza bajo palabra de $2,000.
Thank you, Your Honor.
Gracias, su señoría.
All right, thank you. At this time, Mr. Mojica Paz's bond will remain as set. He is to have no weapons, drugs, or alcohol as a condition of this bond.
Gracias. En este momento, la fianza quedará como se le impuso originalmente y habrá una condición especial de nada de consumo de alcohol ni droga ni tenencia de armas.
Is there anything further from either party?
¿Hay algo más de las partes? No, su señoría.
All right, best of luck to you, sir. I believe that will conclude your case.
Bueno, señor, buena suerte y su caso queda concluido por ahora.
And you can be excused, Ms. Toles. Thank you so much for your
Thank
day.
you, Your Honor.
Have
Everyone
a good
have a great
afternoon.
afternoon. Thank you.
Thank you.
All right, who do we have next? 1,000 surety on each charge, Ms. Bridgewater.
Sure. Thank you.
Who do we have next?
Mr. Wallace, position 19. Mr. Private Attorney?
Good afternoon, Your Honor. That's going to be my case. Pat Dixon on behalf of Mr. Jordan Wallace.
All right, thank you. All right, good afternoon, Mr. Wallace. Your case is 22 CR 0000981Y, in which you're charged with 1 count of battery family violence misdemeanor with an offense date of August the 23rd of 2021. You've heard me advise you of your constitutional rights to an attorney and to remain silent. Do you object to Mr. Dixon assisting you by video or to me conducting a video hearing today?
No, I don't object.
Thank you. I appreciate that. Mr. Howard, I see he's recommended, correct? First arrest?
Yes, Your Honor.
Okay.
It is.
Okay, thank you, Ms. Howard. All right, Ms. Mitchell?
Your Honor, this is position 19.
Yes.
Okay, because I have on my records, this is not a first arrest.
All right, well, give me the state's history, Ms. Mitchell.
Okay, he has history. Let me double check. Yeah, he has 21 cycles in Illinois, 2 cycles in Missouri, and 4 cycles in Georgia. And I'll highlight the relevant one.
Are we on Jordan Wallace?
Yes, we're on position 19. Mr. Howard, you don't see any of that?
No. What's the date of birth you have? Because I got he was born in 1991.
The record.
They make him 30, but I only have 1 arrest.
Double check.
The
Jordan
calendar
Matthew Wallace?
it reflects a birthday of July the 26th, 1991. Ms. Mitchell, is that the birthday that you have?
Let me double check.
That is very divergent criminal
Yeah.
histories. Let's try to reconcile that.
So on Odyssey, it says, let me check. It says the same thing, but let me check the GCIC on here.
Mr. Howard, you have 1 prior arrest or this is first arrest?
I got both. Well, no, I have 1. This is first arrest. He only has 1
Okay.
cycle, which is this arrest.
Which is this arrest, okay.
Correct.
Yes, I on my end, it's the same birthday with all the cycles in the different states.
That is quite interesting. Ms. Mitchell, if you would give us the history that the state has, primarily interested in anything violent, FTAs or probation violations. Mr. Howard, if you could double check. See
Yeah,
why
this
we
is
have.
first arrest. I think it might be on their end. It gotta be.
Hmm.
What's the last 4 of his social? Just the
Put
last
that
4.
in. Can you chat that to Mr. Howard? Ms. Mitchell?
Yeah.
So Judge, I did look through Odyssey myself. There was another Jordan Wallace with a similar DOB in the system. Maybe that's who Ms. Mitchell is referring to, but
Yeah, because that
my
DOB
client's a
is
college student.
820. That DOB is 82691. Jordan Wallace is 726. The one we have is 72691. Yeah, I got the same
Okay.
thing, Shelly. So it's a first arrest. I promise
Okay.
you it is.
All right.
Okay.
The 82691 is a white male.
All right,
Okay.
I'm gonna accept the history as given to me by pretrial services at this time, Ms. Mitchell, unless you have some other information before. Ms. Falk, I see you looking pensive again. Do you have a thought?
No, Your Honor,
Okay.
part of this is contact lenses, but yes, I am looking to, and yes, the NCIC does state white male, so I would advise Ms. Mitchell at this time to continue without the Illinois history, just because based on this information, it appears we may have the wrong GCIC.
All right, Ms. Mitchell, please give me the state's recommendation in light of the history given to us by pretrial. And I do note that he is recommended based on that first arrest and no open cases at this time.
Okay. That'll be adjusted a little bit due to the history mix up, but the state's recommendation is going to be a $5,000 good bond, no further contact with victim Helena, spelled HELENA, Stovall, spelled Stovall, a stay away from 921 Westmoreland Circle, Unit 5104, Atlanta, Georgia. A one-day anger awareness course, and no alcohol, drugs, and weapons. So, Your Honor, in this case, the defendant battered Ms. Stovall, his fiance that he's lived with on and off, by punching her repeatedly, causing a knot to swell over her left eye. It started when the defendant came into Ms. Stovall's apartment, woke her up to see her cell phone, and stated if she didn't show him her phone now, then their engagement will be over. When Ms. Stovall handed her phone, the defendant stated she better not move from the bedroom. As the defendant went through her phone in another room, he began yelling and cursing. When Ms. Stovall went to go see why defendant was yelling, the defendant punched her several times in the face while stating she is a liar and a cheater. Ms. Stovall stated that she was confused and scared because she didn't know why this was taking place. This altercation was so loud, it woke up Ms. Stovall's 2-year-old daughter. This daughter is not related to the defendant. Ms. Stovall believes her daughter crying is the reason defendant stopped punching her in the face. Ms. Stovall stated that the defendant approached her 2-year-old daughter once she woke up, and that's when she jumped in between the two of them with her taser and begged the defendant to leave the apartment. That's when the defendant threw Ms. Stovall's phone at her and told her she better not call the police. Your Honor, okay. Being that this is his first arrest, our main concern here is witness intimidation. We have serious concerns of witness intimidation in this situation. Our victim advocate had a chance to speak with Ms. Stovall, and she was adamant about not pressing charges and stated that the defendant has changed and is so much better now. She also stated that the past violent incidences between them were, quote, not that bad. Your Honor, the victim's entire demeanor screams cycles of domestic violence. Not only has she not denied what has happened in this or other incidences, but she's also showing a pattern of mitigating and minimizing these violent situations by saying it's, quote, not that bad. More specifically, this was only one of 3 domestic violence situations that occurred last year in 2021. Based on the police report, it's also clear that the defendant is used to controlling Ms. Stovall's actions and uses their engagement as leverage, because Ms. Stovall told our victim advocate that she wants to drop these charges because she feels it will ruin their engagement. So that's going to be the basis of our recommendation, Your Honor.
Thank you, Ms. Mitchell. I appreciate that. I see the victim, last name Stovall, is present on the Zoom conference. Ms. Stovall, if you would like to make a statement to the court today, now is your time to do so. Would you like to tell the court? You're not required to do so, but if you would like to speak, you are free to do so. Okay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. What would you like to tell me today?
I think that statement is completely off. He did not punch me multiple times. It was only once. My daughter is not 2, she is 3, and I did not have to get in between them at all. She was not at risk, so I'm not very sure why it was stated that way. And no, I'm not just being dismissive of what's going on. I'm trying to understand why this is going the way it is, because he is so much better than he was. We meditate together. I'm not concerned that our engagement would be off. I'm concerned for his safety because he has changed, and this is over 5 months ago.
Okay. So I guess my question then, do you wish to have contact with the defendant?
Yes, because we do still live on and off with each other, and I am not currently at 921 Westmoreland.
Okay, thank you. I'll go to you now, Mr. Dixon.
Thank you, Judge. For the court is Mr. Jordan Wallace. He's 30 years old, originally from Flint, Michigan. Mr. Wallace moved to Atlanta in 2016 to attend Morehouse College, where he attended on a basketball scholarship. My client graduated in 2020 and continues to reside here in Atlanta, Georgia at 914 Collier Road. This is Mr. Wallace's first arrest in life, and he's not a threat to the victim nor the community. As you heard, Judge, this is a incident from August 2021, about 6 months ago. Since then, both my client and Ms. Stovall have reconciled. There's been no further incidents since then. And my client simply did not know that he even had an outstanding warrant from this situation. And so, Judge, we just asked for a signature bond on this. He's already expended resources on obtaining private counsel. He understands the seriousness of this proceeding and his actions, Judge. And we just ask that you allow him to be released through pretrial services. High likelihood he's going to return to court to answer these charges. My client is not working at the moment. As you know, the court knows bond is not supposed to be punitive. And so we ask the court, based on his history or lack thereof, we ask the court release him through pretrial services.
All right,
And, Your
thank
Honor,
you.
if I may add to that.
Very
Um,
briefly, Ms. Mitchell, yes.
Yes, Your Honor. Everything we stated on our end is from the police report and based on statements Ms. Stovall made to officers. She also reiterated those facts on the phone with our victim advocate. So again, this was one of 3 incidents of last year. Nothing further, Your Honor.
All right, thank you. At this time, Ms. Stovall, I've heard from you. Thank you. I have enough information to make this decision. I appreciate you coming to court. At this time, Mr. Walls is going to receive a $5,000 signature bond through pretrial services. He is to take a 1-day anger awareness course. He is to have no weapons, drugs, or alcohol as a condition of this bond, and he is to have no further violent contact with the victim, last name Stovall. Is there anything further from either party? Mr. Dixon, does that conclude your business with the court today?
Yes, Your Honor. May I be excused?
Yes, you may. Have a great afternoon.
Thank you, Judge.
All right, I believe that concludes Mr. Wallace's case. Can we go to the next position, please?
Yes,
What was
Mr.
that contact again?
Position 3.
No further violent contact.
Okay.
What was that bond amount again, Judge?
$5,000 through pretrial services, 1-day anger awareness. Okay, position 3, are you Cameron Lee Braggs?
Yes.
Mr. Braggs, your case is 22 CR 0000983F, in which you're charged with criminal trespass with an offense date of February 22nd of 2022. You've heard me advise you of your constitutional rights. Do you object to a video hearing today?
No.
Who represents Mr. Braggs?
I do, Your Honor.
Okay, and do you object to Mr. Vail assisting you by video today?
Oh, no.
Thank you. Mr. Howard?
I got 19 total. Last arrest was back in January for criminal trespass, failure to leave campus when directed. That was at Georgia Tech. He has open terroristic threats, 2 counts. 1 count obstruction, 1 count simple battery against police or detention officer. Case number 22 SC 180868. December arrest for criminal trespass. July 2021 disorderly conduct, giving false name, criminal trespass arrest. June 2021 trespass obstruction. May 2020 trespass obstruction. 2019 Georgia State arrest for the terroristic threats and simple assault, obstruction, and disorderly conduct. 2019 theft of services, it was reduced to disorderly conduct time served. 2019 trespass conviction from Georgia Tech. Another 2019 trespass theft by taking conviction, Georgia Tech. 2019 theft by taking arrest from Georgia Tech. 2019 FTA criminal trespass. And a 2018 trespass conviction. And he got history out of Tennessee.
Okay. Thank you, Mr. Howard. Mr. Segura, is this your case?
It is.
All right, and the state's recommendation?
The incident occurred on February 22nd, 2022 at Georgia Institute of Technology, located at 260 4th Street, Atlanta. The officer responded to a call from the university about a person not leaving the premises. The defendant was told several times to leave the premises, but did not do so. We are recommending a $2,000 surety bond, a stay away from the area, Georgia Tech, 260 4th Street, Atlanta, and no alcohol, drugs, and weapons. We're basing this recommendation on the extremely high risk of reoffending. The defendant had 19 total cycles, 10 of which include criminal trespass, receiving 3 arrests for criminal trespass in 2018, twice in 2019, once in 2020, 3 times in 2021 in the span of 6 months from June, July, and December. And there's a recent one for criminal trespass at the same campus on January 27th. In this particular case, the defendant was released on February 10th with the condition of not being stay away from the campus, but in less than 2 weeks, he broke it.
Okay, thank you. Mr. Vale?
Yes, Your Honor. Mr. Braggs is 25 years old. He is homeless. If he is released, he could stay with his father in Memphis, Tennessee, which is where he's from. As his record indicates, he generally stays in the area of the Georgia Tech campus, but he has nowhere else to go. And while I understand that he is not supposed to be on that campus, he was looking for a warm place to sleep at night. He cannot afford anything other than a signature bond, so we would request that.
Okay.
I would like to add that he also has an associate's degree in management from Middle Tennessee University. So at one point, things were going well for him, and then he suffered some financial setbacks and became homeless.
All right, thank you, Mr. Vale. I appreciate that. All right, at this time, Mr. Braggs, you're going to receive a $2,000 signature bond through the jail. You absolutely must stay away from that from the Georgia Tech campus. You cannot return there. And you must understand that I am allowing you out, but if you decide to return back, the jail will welcome you with open arms, as you'll be violating your bond. You are to have no weapons, drugs, or alcohol as a condition of this bond.
Okay.
Is there anything further from either party?
No, Your Honor.
No, thank you, Your Honor.
All right, Mr. Braggs, I've warned you. All right, best of luck to you. Do not return to that campus.
Okay.
All right, thank you. All right, best of luck to you, Mr. Braggs. What do we have next?
Position 4 and 5, Mr. Chambers.
4 and 5. Okay. Good afternoon, Mr. Chambers. You have 2 cases. Your first case, 22 CR 0000975C. You're charged with 3 driving offenses: driving on expired license, improper lane change, and reckless driving with an offense date of May the 28th of 2021. And in your second case, you also have 3 driving offenses with an offense date of June the 20th of 2021. I've advised you of your constitutional rights. Do you object to a video hearing today?
No, ma'am.
Is it you, Mr. Vale, again?
Yes, Your Honor. I represent 1 to 11 on the calendar.
Okay, thank you. And do you object to Mr. Vale assisting you by video?
No, ma'am.
All right.
This is second arrest.
Okay.
Our last arrest was last month in Gwinnett. Ag assault, 2 counts. 2 counts for criminal trespass. 1 count unauthorized discharge of a firearm near public highway. That's open in Gwinnett County.
Any other driving history?
This is second arrest. I don't have his driving history. State
You don't have his
may
driving
have that. Yeah, state may have that.
Ms. Guidry, do you have the driving history?
Yes, he has 2 citations for speeding. One he pled guilty to in December 15th of 2021. He was driving 116 in the 65. And the second one was from 2019, January 22nd. He pled NOLO. He was driving 93 in the 65.
Okay. All right, what's the state? Let's try to do both cases together if we can. If you could give me the recommendations for each count, I'll try to write them down. What's the state's recommendation first for the first case?
For position 4 ending in 975C, he currently has a bond of $1,465. For count 1, it's $200. For count 2, it's $265, and for count 3, it's $1,000.
Okay, and the state recommends that remains the set?
Yes, and that
Okay.
you issue no driving of the ATV.
Okay, you know what, Miss Guidry, why don't you give me the facts of this one?
Okay.
This was an ATV he was operating?
Yes. So this case occurred on May 28th of last year on Peter Street Southwest. Officers was assigned to investigate the ATV and dirt bike riders of the area. While browsing Instagram, the officer came across an Instagram page belonging to the defendant who was seen in a video riding an ATV on Peter Street Southwest. He was seen doing wheelies on the ATV while a vehicle was following him to film him. He then headed southbound on Peter Street, continuing to do wheelies and split the dotted white line and didn't stay within his lane. The officer was able to observe that he had no license plate affixed to the ATV, and officers also obtained video footage from the area of Peter Street. Given his criminal history, that he has an open case, and his speeding citations, we ask that you maintain that bond in this case. Would you like for me to go with the second case?
Yes, yes, please.
Okay, in the second case, he does not have a bond set. We're asking for count 1, you issue a $500 surety. For count 2, $1,000 surety. And for count 3, a $500 surety, making it a $2,000 surety. And again, no driving of the ATV. This incident occurred in June 20th of 2021. An officer was traveling southbound on Northside Drive in the left lane. He was attempting to turn left onto Ivan Allen Jr. Boulevard when he was stopped at a red light. While waiting for the light to turn green, he noticed 2 ATVs maneuver around vehicles at the red light on the Northside Drive. The 2 ATVs then ran a red light. The officer saw the individual's face and identified the individual as the defendant from the previous case, because he had already taken out warrants in the previous case. The ATV that the defendant was driving was the same ATV in the previous case. Again, given that this is his second time, and given the open case that he has, we're asking that you maintain the bond in the first case and issue the second bond as stated.
All right, thank you. Mr. Vale?
Yes, Your Honor. Mr. Chambers is 24. He was born and raised in the Atlanta area and still lives here. He's a graduate of Carver High School. He has very strong ties to the community. His mother, father, and 7 siblings all live here in the metro area. He works as a mover. He is facing some very serious charges in Gwinnett County, but of course those charges are not before the court. So we would be asking for a signature bond in both of these cases.
All right, thank you, Mr. Vale. At this time on for the case ending in 975C, Mr. Chambers' bond will remain as set, and he is to have no driving of the ATV, no weapons, drugs, or alcohol as a condition of that bond. For case ending in 978C, for count 1, failure to obey signs, it'll be a $200 surety bond. For count 2, for the reckless driving, it's going to be an $800 surety bond. And for the improper lane change, that'll be a $500 surety bond, for a total of a $1,500 surety bond with the same conditions of no driving of the ATV, no weapons, drugs, or alcohol. Is there anything further from either party?
No, Your Honor.
All right, best of luck to you, Ms.
Excuse me, Judge. On that first case, will you break down that bond for me?
Yes, ma'am. I believe it was 200, count 1, 265, count 2, 1,000, count 3, for a total of 1,465.
That's correct.
I'm doing well with that lately. All right. Best of luck to Mr. Chambers. Let's move to the next position.
Position 6, Collins.
All right, good afternoon, Mr. Collins. Your case is 22 CR 00977E, which you're charged with battery family violence with an offense date of January the 3rd of 2022. Do you object to the video hearing?
No, ma'am.
Do you understand your constitutional rights?
Yes, ma'am.
And do you object to your attorney assisting you by video?
No, ma'am.
All right, thank you, Mr. Howard.
Second arrest. Last arrest was 6 days ago, misdemeanor possession of marijuana. He went to the city jail for that. That's it.
Okay, thank you. All right, Ms. Guidry.
Yes, Your Honor, we're recommending a $3,500 surety bond. No further contact
Can we
with
go back?
Nastasia, that's Nastassja Lee. Common spelling, a stay away from 415 Fairburn Road Southwest, apartment 1713 in Atlanta. 1-day anger awareness and no alcohol, drugs, or weapons. Your Honor, this incident occurred on the 3rd of January 2022 at the location. Ms. Lee arrived at the precinct and stated that she was punched from the right side of her face by the defendant, whom she had been living with for a year. After the assault, she stated that she feared for her safety and left the location without calling 911. Officers observed Ms. Lee's right side of her cheek to be swollen, and her injuries were captured on the officer's body-worn camera. The defendant was identified by Ms. Lee using a picture officers downloaded from their system called Omnix. Your Honor, we do understand that this is the defendant's first violent arrest, given that he was only arrested for marijuana. However, given the nature of the crime, we're asking that you give the bond as stated. We did talk to the victim. She stated that they are still living together and they are in a relationship. She did say that she would like no violent contact. However, we oppose that given the nature of this crime, and that she did say that she feared for her safety. So we ask that you give the bond as stated.
All right, thank you, Ms. Guidry. At this time, I'm going to sound for the victim, last name Lee. Ms. Lee, if you are present on the Zoom conference and would like to make a statement, this is your opportunity to do so. I do not see a Ms. Lee on this Zoom conference. So we will go to you, Mr. Vale.
I'm actually here. I'm sorry.
Okay, Ms. Lee.
I have my, yeah, I'm sorry.
That's fine. Please raise your right hand. Do you swear and affirm that the testimony you give today will be the truth under the penalty of perjury?
Yes.
All right, what would you like to tell the court at this time?
I was just want to say I wasn't fearing for my life. I basically was just leaving the house, just trying to calm down the argument. That's all. I just left the house and went to my mom and was just talking to my mom. I don't fear. I'm sorry. I don't fear for my life.
Your Honor.
Let me let Ms. Lee finish, and I'll allow you to speak or respond, Mr. Vale.
Well,
go ahead, Ms. Lee. Go ahead, Ms. Lee.
Okay. I don't fear for my life. Deontay is actually a good person. He helps me with everything I need help with. So yeah, it was just something that got out of hand. We are young. I am young. And it's just something that got escalated. So I do hope you can, yeah.
Thank you, Ms. Lee.
Thank you.
I appreciate it. Thank you, Ms. Lee. Mr. Vale, go ahead.
Yes, Your Honor, and I do apologize for the interruption. It's just that as we're just here to decide on a bond, I would respectfully object to basically testimony about the facts of the case at this stage.
Your Honor, if I may answer that.
Please let Mr. Vale continue, Ms. Guidry. I'll let you respond since I did allow the victim to speak. All right, Mr. Vale.
Mr. Collins is 27 years old. He is originally from Baltimore, Maryland. He has lived in Atlanta for 10 years and works for Amazon as a delivery driver. He is a graduate, high school graduate from Maryland. We would ask for a signature bond in this case. As the state mentioned, he has no substantial criminal history, and the victim has also asked for no violent contact as opposed to no contact. So we would ask for that as well.
All right, thank you, Mr. Vale. Ms. Guidry, I'll allow your response. I believe that you're going to speak to the nature of the witness's testimony and what it's useful for. I believe we've all discussed this, but I'll allow you to put that on the record very briefly.
Yes, just as Your Honor stated, the victim may speak to any facts in regards to the Ayala factors in which she has stated. So that's why we're asking that she continue to make any statements. And that's all.
All right, thank you. At this time, Mr. Collins is going to receive a $3,000 surety bond. He is to have no further violent contact with the victim, last name Lee. He is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank
Is
you,
there
Your Honor.
anything further from either party?
Nothing.
All right. If
No.
nothing else, best of luck to you, Mr. Collins. Who do we have next?
Position number 8 at the South Annex, Your Honor, Ms. Foot.
All right, good afternoon, South Annex. This is Ms. Foot, your case is 22 CR 000982F, in which you're charged with simple battery with an offense date of October the 4th of 2021. I want to advise you, you have a constitutional right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding, and Mr. Vale is present on this Zoom conference to assist and represent you. Do you object to a video hearing or to Mr. Vale assisting you by Zoom?
No.
Okay, thank you. She's recommended first arrest, Mr. Howard.
Yes.
Thank you. Ms. Guidry.
Yes, Your Honor, we're recommending a $3,000 signature bond, no further contact with Donna Ransom, a stay away from 3114 Collier Drive, Northwest Atlanta, which is Mary Shy Scott Memorial Park. 1-day anger awareness and no alcohol, drugs, or weapons. Your Honor, this incident occurred on October 4th of 2021. They responded to the park. They spoke with Donna Ransom, who stated that she was in the dugout speaking to the football coach about their use of profanity towards the children. When the defendant charged into the dugout, grabbed her by her hair, and punched her in the head multiple times. Ms. Ransom stated that she called the police twice, however, her calls went to voicemail. They called her back nearly an hour later, but she declined due to her leaving the scene. Mr. Rodney Lowton, who was a witness, corroborated Ms. Ransom's statements, and he also stated that he didn't understand why the defendant assaulted Ms. Ransom and that there was no reason. Ms. Ransom did not have any visible injuries, and she was able to identify the defendant after officers obtained a photo of her driver's license. Given that this is the defendant's first arrest and that this is a simple battery, we're requesting a signature bond.
Okay, I just want to clarify, it is a signature bond, not surety, correct?
A signature.
Okay. I see the victim is present on the screen. Ms. Ransom, if you'd like to make a statement, this is your opportunity to do so. Do you wish to make a statement? You are not required to do so.
Yes, ma'am, I would like to.
Okay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
Okay, what would you like to tell the court today?
I would just like to tell the court that I'm still to this day in a state of shock about what happened, because I was the team mom of a Pop Warner football team, and I dedicated a lot of my time, my kids. I paid a lot of money for my kids to participate. I'm originally from Tallahassee, Florida, and I moved to the Atlanta area in November of 2020. And I was really just trying to just be there for the kids and just kind of like let the coaches know that, the profanity used against the children, it was a bit much. And I don't know if that upset Miss Foot or whatever, but I was really advocating for her child who was spoken to very rough, by a coach. And I don't know if she, misunderstood the situation, but I've never had an issue with her. Always a good parent towards her child. I just don't understand. I can't make out anything of it, and just speaking on that day and just trying to be an advocate for the kids, she just literally just ran towards me in an attack mode. And I just, in front of my kids, it was about 50 other children in the area, in the park. It was after football practice. And that was the first time my children have ever experienced someone hurting me. And, I was forced to have to defend myself the best that I could. And for that to happen in front of my children, that's something that still scars them to this day, because I don't teach my kids to provoke anyone or to initiate a fight with anyone. That's something that I always taught my kids against. And I just could not understand how something like that could just happen to me when I know how much good I've done. I fed the team. I've done a lot for that team. So after that incident, I had to pull my kids out of something that I invested a lot of money into. I paid for uniforms, shoes, football pads, helmets, and my kids couldn't even experience the rest of the season because I didn't feel comfortable going back out there, going through that situation and driving home when I'm in a frantic mode with my children. I could have, ran off the road just out of a state of confusion, but I'm not from this area. So it really put me and my family in harm's way dealing with something of that nature. And I just really don't understand what was it caused for.
because I would have never in my mind thought that I've done something that bad for just speaking up for her to handle me the way that she did.
All right, Ms. Ransom, I appreciate you making that statement and coming to court today. Mr. Vale?
Your Honor, it's my understanding that the state has requested a signature bond. That's acceptable to the defense if the court's inclined to grant that. However, given the alleged facts, I think perhaps instead of stay away from the football field, staying away from having no contact with a victim, I think might be more appropriate. My client does work as a preschool teacher and is involved in youth sports, so may have a need to pick up her children there.
All right, thank you, Mr. Bell. At this time, I am going to accept the state's recommendation in its entirety and include that stay away from the park. She's also to have no further contact from the victim. She will receive the $3,000 signature bond through pretrial services at this time. No weapons, drugs, or alcohol as a condition of her bond.
Thank you.
Is there anything further from either party?
Nothing further.
No, Your
All right. Best of luck to you, Ms. Foote. All right, who do we have next?
Position 12, Mr. Lindsay.
Okay, are you Wendell Lindsay?
Yeah.
Mr. Lindsay, your case is 22 CR 000971C, and what you're charged with criminal trespass and damage to property with an offense date of February the 22nd of 2022. You've heard me advise you of your constitutional rights and your rights to an attorney at this proceeding. Do you object to the video hearing today?
No.
Do you object to Ms. Kim assisting you remotely?
No.
Your Honor, I would like to request for 1 second breakout room to just address one issue and then come back. 1 second.
Okay. Are there other positions today that are going to need breakouts following this? Position 12, is there anyone else that we're aware of that needs a breakout?
Not for me, Your Honor.
From the state, are there other positions following this that will need a breakout room?
Yes, position 20.
Okay, if we could go to position 20 after this so we can end the breakouts, that would be great. All right, please place me, Ms. Kim in a breakout, Ms. Falk, Ms. Mitchell, Ms. Bridgewater. Did I miss anyone? Ms. Kim, Ms. Falk, Mrs. Segura, Ms. Mitchell. I'm not sure if Mr. Vale would like to be in as well.
Yes.
Yes.
I don't have his history, so I'm gonna defer to the state.
Okay,
If y'all
that's
want to
fine.
discuss it in the breakout room.
Okay.
Real quick, Judge, real quick, position 20 is a reset.
Okay, wonderful. All right. Thank you for letting me know.
You're welcome.
Okay, if we can get into that breakout room.
Okay, one moment. Is Ms. Gidry going in? No.
Ms. Gidry, are you? I don't believe she is.
Okay.
No.
Ms. Mitchell, Ms. Falk, Mrs. Segura, Ms. Kim, and Mr. Vale. All right, at this time, if everyone has returned, excuse me, from the breakout, Mr. Lindsay is going to receive a $1,500 surety bond. He is to undergo evaluation as we discussed. He is to have no weapons, drugs, or alcohol without a prescription as indicated as a condition of this bond. Is
Your
there
Honor,
anything? Yes.
May we add no further violent contact for those that were involved in this case?
I don't have an objection. What were those names? That was what I was trying to get at. What were the victims' last names?
The driver was Richard Leigh, spelled Leigh, and then the other passenger was James Porter.
All right, and he is to have no further violent contact with those victims. All right, that will conclude Mr. Lindsay's case. Best of luck to you, sir.
You're not talking.
Mr. Lindsay, anything you say can be used against you. The best person to direct your questions to is Ms. Kim. If you have a very limited question about your bond, I'll allow you, I will hear it. What is your question?
Yes, Ms. Kim, is it possible if I can be released from all the stuff I've been going through over there?
I don't want you to say something, Mr. Lindsay, by mistake. Ms. Kim, will you please speak with him following this proceeding?
Yeah, I'm talking about being
you have a-
released, like the counselor said, to some kind of anchor.
Mr. Lindsay, I don't want
Lindsay?
you to say something that the state may inadvertently hear. Please give Ms. Kim a call. Ms. Kim, please call Mr.
Yes.
Lindsay. All right,
Yes,
thank
I'll
you.
do that.
All right, who do we have next?
Position number 9 at the South Annex, Miss George.
Can I give
Okay.
you Kim's phone number? That's all I ask, Miss Kim's phone number.
Ms. Kim will contact you.
I'll call you,
Lindsay.
Mr. Lindsay.
Okay, good afternoon. Are you, please pronounce your first name for me.
Ifatayo.
Miss Ifatayo George, your case is 22 CR 0000985C, in which you're charged with 1 count of simple battery family violence. I want to advise you, you have a right to remain silent. You have a right to an attorney at this proceeding. Anything you say regarding the facts of the case can be used against you. Do you object to a video hearing today or to your attorney, Mr. Vale, assisting you by video?
No, ma'am.
Okay, thank you. Mr. Howard, can I have her history?
5th arrest. Last arrest was on the 13th of this month. Criminal damage to property, 2nd degree, out of the city of South Fulton. 2015 driving without a valid license. 2014 FTA for a fray. That was NOD. Another 2014 2 failure to appears, not prosecuted.
Okay, thank you. Ms. Guidry?
Yes, Your Honor, we're recommending a $2,500 surety bond. No further contact with Jarrell Williams, common spelling, and he is on the line. A stay away from 48 Finch Drive, Southeast Atlanta. 1-day anger awareness, third-party transfer any children, and no alcohol, drugs, or weapons. In this case, officers responded to the location on October 26, 2021. They were met by the defendant, who stated that the father of her children, which is Mr. Jarrell Williams, had punched her in the face twice. Officers noted that the defendant's statements did not align with her injuries. After speaking with her, they spoke to witnesses Kimberly Germain and Jarius Johnson, who stated that the defendant was arguing with Mr. Williams about a bullet lying on the floor in the living room. When Mr. Williams told the defendant to pick up the bullet, Mr. Williams told the defendant to pick up a bullet because he didn't know where it was. She became irate and she slapped him. Mr. Williams then shoved the defendant, and that's when Mr. Johnson began to separate the two. Due to the nature of this offense, and given the fact that the defendant tried to lie about injuries occurring to her that didn't happen with Mr. Williams, we're asking that you get to the stated bond. We also talked to the victim. He stated that they are no longer in a relationship and they do not live together. He wants no contact with the victim, and the incident location is his residence. So that's why we maintain that stay away.
All right, thank you.
You're welcome.
I'm gonna hear from the victim at this time. Last name Williams. Mr. Williams, if you are present on the screen, please turn on your camera. All right, would you like to make a statement to the court today?
Yes, ma'am.
Before you begin, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
And you also confirm, you can put your hand down, but also confirm that you do not have any relationship with me, as my last name is also Williams. You do not know me personally, correct?
Yes, ma'am. No, ma'am.
All right, thank you. All right, what would you like to tell the court today?
The incident, it occurred a while back, but before the incident happened, I mean, after the incident happened, you know, we've been on good terms. You know, she's having to take care of the kids, you know, a lot by herself, you know, due to me not having really a stable job or whatever. So she is very much needed out here on the streets, you know. Like I said before then, after the incident happened, you know, we've been on good terms, you know, I've been helping her out with everything what I can. And she's needed out here on the street. Like, and you know, that's all I can say. Like, and we have kids together, so we're gonna have to have some type of contact with each other. So I just, you know, I want to still continue to help her at the same time if she'll allow me to help her.
So you're telling me you'd like to have contact with Miss George and you'd like her to be able to return to the Finch Drive address?
See, this is my residence, but I'm not the owner of the house. So I can't say if she's able to come and go, but you know, she can come, stop by and get the kids and we can see each other like that or whatever. But as far as like her coming to visit, I don't know because this is not my house. I'm not the owner of the house. I just stay here with my family.
All right, I understand. Thank you, Mr. Williams. All right, Mr. Vale.
Your Honor, Miss George is 27. She was born and raised in Atlanta, graduated from Campbell High School, and currently works as a waitress at the Cheesecake Factory. She does have 2 children, aged 4 and 5. The 5-year-old's birthday is tomorrow. I would just like to point out that, as the state mentioned, Miss George is the one who called the police and indicated that she was the victim of an incident of domestic violence. Other than having contact with the children and picking them up, she has absolutely no interest in having further contact with Mr. Williams, other than what's necessary to look after their 2 children. I would also like to mention that, at least as alleged, this argument was about ammunition being left lying around in a home where very young children reside. So if that in fact happened, I think it would be rather understandable for Miss George to be angry about that. Anyway, for those reasons and her ties to the community, we would be asking for a signature bond.
All right, thank you. At this time, Miss George is going to receive a $2,500 surety bond. She is to have no further violent contact with the victim, last name Williams. She is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further.
No, Your Honor.
All right, best of luck to you, Miss George. Who do we have next?
Position 11, Ms. Korjak.
Okay. Good afternoon, Ms. Korjak. Your case is 22 CR 000970G, in which you're charged with obstruction with an offense date of February 22nd of 2022. You've heard me advise you of your constitutional rights. Do you object to a video hearing today, or do your attorney assisting you by video?
No, ma'am.
Okay, thank you. Recommended, right, Mr. Howard?
So be jail.
Recommended through the jail. First arrest?
Number 5, but also he has DUI and marijuana possession.
Okay. All right, thank you. Ms. Mitchell.
Yes, Your Honor. This case is also related to positions 13 and 14, but on this case, we're going to recommend a $3,000 signature bond and no alcohol, drugs, and weapons. The defendant, Korshak, obstructed and hindered officer's duty by constantly grabbing officer's hand while he was attempting to arrest the cross defendant in the other case, Martin, even after defendant Korshak was told to step away. So that's all we have, Your Honor.
Okay, $3,000 signature through the jail, no conditions, correct? You're not asking for any conditions.
Just no alcohol, drugs, and weapons, but.
Okay, and I'm sorry, I forgot to clarify, who represents Mr. Korchak?
Mr. Benchita, Your Honor.
Okay, good afternoon, Mr. Benchita. Do you object to the state's recommendation that she receive a signature bond through the jail?
No objection, Your Honor.
All right. At this time, Ms. Korchak is going to receive a $3,000 signature bond to the jail. She is to have no weapons, drugs, or alcohol as a condition of this bond. And if there is nothing further, that will conclude her case. And best of luck to you. Mr. Benchita, I believe that will conclude your business with the court. It does not.
We
Okay.
appreciate it.
All right. All right, who do we have next?
Your Honor, what did position 11 get?
Position
I'm
11
sorry.
is a $3,000 signature bond through the jail.
Thank you.
Thank you. All right, who do we have next?
This is our last case, Judge. Position 14, Mr. Maxey.
Okay. Mr. Maxey, your case is 22 CR 000972E, in which you're charged with disorderly conduct with an offense dated February the 22nd of 2022. I've advised you of your constitutional rights. Do you object to the video today?
No.
Do you object to your attorney assisting you by video?
No.
Ms. McLeod, do you represent him?
I do, Your Honor.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, we're going to recommend a $3,000 signature bond in this case as well. No further contact with Brianna Martin, the cross defendant, 1 day anger awareness, and no alcohol, drugs, and weapons. And we also plan to provide the similar recommendation for Ms. Martin. Your Honor, in this case, the defendant Martin and defendant Maxey got into a physical and verbal altercation. Defendant Martin knocked defendant Maxey's cell phone out of his hand and threw rocks at him. Defendant Maxey was loud, boisterous, and used profanity during the incident, and both defendants stated that they were physically assaulted by one another.
Okay.
That's all we have, Your Honor.
Thank you. Ms. McLeod, do you have any objection to the state's recommendation?
Yes, Your Honor, not to the signature bond. I'm fine with that, but I do object to the anger awareness. My client is 27 years old. He has a degree from Morehouse College. He works. He's gainfully employed in the city. He says that he was the victim, in that he was just having a conversation, and this is not someone he knows, incidentally, and it escalated, and this person essentially entered into the conversation, and the person struck him. He did not have any physical contact with the person. So he feels like he is a victim, Your Honor. He has no criminal record whatsoever.
Okay, thank you, Ms. McLeod. At this time, I am going to accept the state's recommendation with the exception of the 1 day anger awareness course. Mr. Maxey is going to receive a $3,000 signature bond through the jail. He is to have no further contact with Brianna Martin and no alcohol, drugs, or weapons as a condition of this bond.
Thank you, Your Honor.
All right, is there anything further from either party as it pertains to this case?
No, Your Honor.
All right. All right, Bessie.
Let me ask you this, on Brianna Martin, what was her bond?
We didn't do her yet, Ms. Bridgewater.
Okay, I know we had said.
What was your bond amount?
3,000 signature.
All right, that will complete Mr. Maxey's case, and I believe that concludes the business at courtroom 2 as well. Is that correct?
Yes, that's correct. You said it was 3,000. Is it good or a signature bond?
Signature bond through the jail.
Thank you.
Your Honor, I have one more mail. Tobias Jackson, position 10.
Position 10. Listen, that's going to be a position. Position 10 is going to be a reset as well.
Okay, position 10 will be reset. Does that conclude the entire calendar?
No, Your Honor.
Okay, I didn't think so. We didn't do Ms. Martin yet. Okay.
Keep your voice down, please.
Okay.
Ms. Martin is position 13, Your Honor.
Okay. Are we ready to go to position 13?
Yes. Yes, Your Honor.
All right. All right. Good afternoon, Ms. Martin. Your case is 22 CR 00973G, in which you're charged with disorderly conduct with an offense date of February the 22nd of 2022. I've advised you of your constitutional rights and your rights with an attorney today. Do you object to your attorney assisting you by video or to a video hearing?
No, Judge.
Thank you. It's my understanding that the state's recommendation is a $3,000 signature bond with the jail. Were there any other conditions, Ms. Mitchell,
Yes.
other than no further contact with, I've already forgotten the young man's name. What was the person that she's having no further contact with?
Timothy
Maxie,
Maxey,
last name Maxie, and no weapons, drugs, or alcohol?
and a 1-day anger awareness course.
Okay, 1-day anger. Thank you. And Ms. Kim, this is your case?
Yes, Your Honor. We agree with everything except anger awareness because she doesn't, it was not her anger issue. She was basically defending herself from the attack that Mr. Maxey had. So it was completely self-defense, and she's very intelligent, and she is gainfully employed in city of Atlanta. She has been working there for more than 5 years, and she even has a 2 business as well. I don't think she has any anger issue, Your Honor. So we would like to remove that condition, and everything else, we are very fine. Thank you.
Thank you. At this time, Ms. Martin is going to receive the same $3,000 signature bond through the jail. She is to have no further contact with the defendant, last name Maxie, and she is to have no weapons, drugs, or alcohol as a condition of her bond.
Thank you, Your
And
Honor.
that will conclude her case unless there's anything further from either the state or defense at this time.
No, Your Honor.
All right, I believe that concludes the entire calendar.
No,
as we
Your
had it.
Honor. No, Your
No?
Honor. Position 18.
Oh,
It's Tawana Simons.
I pulled the trigger too early. We have Tawana Simon, case 22 CR. Okay. Ms. Simon, your case is 22 CR 0000976B, in which you're charged with terroristic threats with an offense date of January 3rd of 2020. You've heard me advise you of your rights. Do you object to a video hearing today?
No, ma'am.
Do you object to Ms. Kim assisting you by video?
No, ma'am.
Okay, thank you. Mr. Howard?
21 total. She got history out of Georgia and Florida. She had 2019 terroristic threats, simple assault. Simple assault. She pled no load to that in Clayton County. Last arrest in Florida. Got a 2020 battery on a nurse out of St. Petersburg. 2020 petty theft. Those appear to be open. 2020 burglary. 2015 battery, felony domestic related. Said charges were dropped in that case. 2013 public drunk. Charges were dropped. What else? She got some marijuana possessions, convictions. I got a robbery conviction from, let's see. Oh, that's 2003. That's it.
Okay, thank you. Ms. Mitchell?
Yes, Your Honor, there's a current $2,500 good bond on this case, and the state requests that that bond remain the same with the conditions of no further contact with Shanquita, spelled SHANQUITA, Grant, a stay away from 435 Joseph Lowry, Atlanta, Georgia, a 1-day anger awareness course, and no alcohol, drugs, and weapons. Your Honor, on January 3rd of 2020, the defendant threatened Ms. Grant by stating, quote, "I will beat your ass." The state's concerns here is defendant's risk of reoffending. As heard from pretrial, she's a convicted felon with history in Florida and Georgia. She appears to have 3 unresolved or open cases in Florida, including battery, theft, and burglary, all in 2020. The defendant was also convicted of terroristic threats and simple assault in Georgia in 2019, where she pled no low, and a fighting conviction in 2011. We're also concerned that defendant may be a flight risk. Defendant may not have sufficient ties here in Georgia based on the fact that a majority of her history comes from Florida. We're also concerned that defendant is fleeing from her open cases in Florida and that she may do the same in Georgia. Yes, and that's the basis of our recommendation, Your Honor. Thank you.
And it was $2,500 is what is currently set, Ms. Mitchell?
Yes, Your Honor.
Okay, thank you. Ms. Kim?
Yes, Your Honor. The past conviction or any kind of arrest should not be prejudicial because this one is kind of totally different from like what happened in the past. She was literally just being a little bit in a wrong way cute. She wanted to just, make a joke and kind of break the ice, and it kind of came across wrong way, I guess. It's not, she did not have any kind of intent to harm anybody. It was not even terroristic threat. It was a simple, it was very joke that it kind of took it wrong way. But anyway, she is not a flight risk because she has a job here in Georgia. I mean that, and then she's working as a repair person for the mobile homes, and she's mature enough, 44 years old, and we do not oppose any other conditions except that $2,500 should be a signature bond, Your Honor. Thank you.
All right, thank you. At this time, Ms. Simon is going to receive $1,000 surety bond. She is to have no further contact with the victim, last name Grant, and she must stay away from the 435 Joseph Lowry. She is to have no weapons, drugs, or alcohol as a condition of this bond. All right, is there anything further?
No,
That's
thank
it,
you.
Your Honor. We're finished.
All right. Have a great afternoon at the South Annex. Miss Bridgewater, will you please review the calendar for me?
Would love to do it.
All right.
Okay, here we go. Again, the reset date for the SAP calendar is going to be March the 8th. Position number 1 is reset further notice with a $2,500 SOB through pretrial. Position 2 is reset to the SAP calendar with a $2,000 total good bond. Position 3, reset further notice with a $2,000 SOB through the jail. Position 4 is reset to the SAP calendar with a total good bond of $1,465. Position 5 is reset to the SAP calendar with a total good bond of $1,500. Position 6 is reset to the SAP calendar with a $3,000 good bond. Position 7 is reset to the SAP calendar with a total split bond of $2,500. Position 8 is reset further notice with a $3,000 SOB through pretrial. Position 9 is reset to the SAP calendar with a $2,500 good bond. Position 10 is being reset till tomorrow. Position 11 is reset further notice with a $3,000 SOB through the jail. Position 12 is reset to the SAP calendar with a $1,500 good bond. Position 13 is reset further notice with a $3,000 SOB through the jail. Position 14 is reset further notice with a $3,000 SOB through the jail. Position 15 reset further notice with a $2,000 total SOB through pretrial. Position 16 is reset to the SAP calendar with a $2,000 total good bond. Position 17 reset further notice with a $5,000 total SOB through the jail. Position 18 reset to the SAP calendar with a $1,000 good bond. Position 19 reset further notice with a $5,000 SOB through pretrial. And position 20 is being reset till tomorrow. Are there any questions, concerns, or
Yes.
comments? Okay,
Number 15.
number 15
Hold on.
is,
Was that no? I got the bond. Is that inmate? Because I think y'all went to the breakout for that one, but I don't know why.
Yes.
let me pull
Okay.
Yes,
'Cause I gotta
it
send
is.
them to the right case manager. That's why I was asking.
Yes,
And
it is.
number 5. What was the bond amount for number 5?
on number 5, that bond amount is $1,500 total good bond. 200 on number 1, 800 on number 2, and 500 on number 3.
Okay, so what was number 4? I'm sorry.
Okay, number 4 is $1,465 total good bond. On number 1, it's $200.
Oh, I just
Number
need the total, thank
Okay. Are there any others?
you. No, I'm good now.
And please, if you have not already done so, send me those eval orders so I can send it to the judge to sign.
All right, hearing no further comments, changes, or corrections, we will be in recess until tomorrow at 2 p.m., which is February the 24th, 2022, at which time Judge Law will be presiding. I will see some of you on Friday. Until then, take care. Have a great one.
Thank you, Your Honor. Have a good day.
All right, bye-bye.